Welcome to the second and final semifinal round of the February 2025 International Mock Trial Competition. I'm thrilled to introduce the judges for this prestigious tournament. We're down to the top 4 out of 44 teams. We'll begin with Judge Drew Ashlock.
Hi guys, my name is Drew. I have been doing mock trial for a long time. I did 3 years of high school mock trial out in California. Then I competed for 4 years at UCLA. I'm now a first-year law student at the University of Texas School of Law, where I still compete in mock trial and coach undergraduate mock trial. I'm very excited to watch these rounds. I've heard y'all are very good. Do something fun and that you didn't do in the prelim rounds. That's my suggestion. Do something new this round so it stays fresh and exciting.
Next is Judge Alexandra Challa.
Hi everyone. I started mock trial when I was around your guys' age, and it makes me really happy to see this program is still thriving. And regardless of the outcome today, I think you should all be very proud of yourselves, and I'm really excited to see what you guys perform tonight.
Last but not least, our presiding judge. You know him, you love him. Here's Joshua.
Hey guys, so I'm Joshua. I'm current competitor for UC Santa Barbara, and as a high school competitor a few years ago, I actually competed in IMT. We didn't have quarters or semifinals, nothing like that. We just had 4 prelim rounds. So my word of advice is really cherish this opportunity and make the best of it. Good luck to both teams.
Good luck to everyone. I'm not going to be turning cameras off. The only camera that will be on, of course, is Judge Joshua's until the competitors are called. Judge, the floor is yours.
All right, let's call the case of State v. Tanks. Can we get appearances from the prosecution?
Yes, Your Honor. May we ask your time zone?
Of course, it's 6:08 p.m. for me. I'm currently in California.
Yes, sir. Good evening, Your Honor, opposing counsel, and members of the jury. My name is Blanar, spelled B-L-A-N-A-R, counsel for the people.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Danzya, spelled C-U-R-R-Y, counsel for the people.
Good
Your
evening.
Honor, may my witnesses make appearances?
Of course.
Good evening, Your Honor. My name is Anjalayna Chatoori, and today I am Billy Huxley.
Good evening.
Good evening, Your Honor. My name is Maryska Campbell, but today I am Dr. Harley Blaze.
Good evening. All right, defense, any introductions?
Hello, Your Honor. My name is Christiana Garcia, and today I'm joined by my friend, Audrey Ma.
Good evening, Your Honor.
Good evening.
And Miss Ma just so happens to be my colleague. We're here on behalf of Miss Jimmie Tanks.
Sounds good. All right, prosecution, do you have any housekeeping preliminary matters for me?
Yes, Your Honor. The prosecution would like to invoke Rule 615, constructive sequestration of all witnesses, with the exception of the party representatives, in this case, the defendant, Jimmie Tanks.
Sounds good. Any objections from the defense?
No, Your Honor. We would just like to identify Miss Tanks as our party representative.
Fantastic. Anything else, prosecution?
Your Honor, may we assume under 603 that all witnesses are pre-sworn?
Of course.
All right. And we would also like to ask your preferences on screen sharing. Do we have to ask permission every time, or do we have leave to screen share and make notation for the record?
Please just state it for the record. No need to ask for permission.
Yes, Your Honor. And with that, the prosecution is ready to proceed with openings.
Fantastic. Anything from the defense?
Yes, Your Honor. We would like to know Your Honor's preferences when it comes to striking objections. Should we ask or simply assume it's stricken?
Please move to strike offending testimony.
And second, we would like to bring the court's attention to case law State v. White 1904. As we can see, Your Honor, State v. White 1904 states, in a criminal case, the burden of proof is beyond a reasonable doubt with respect to every element of the charge offenses. The burden is on the state and never shifts to the defendant.
The court will so note. Thank you.
And with that, Your Honor, we're ready to get this show on the road.
Sounds good. Prosecution openings whenever you're ready.
Yes, Your Honor. Revenge is the fire that consumes. On July 1st, 2024, Bertie Darrow learned this the hard way. It started as a normal day at first. He arrived home from the grocery store, dropping off his groceries like he always does. Today, something was different. The smell of gasoline hit Darrow's nose. Oh, it's probably nothing, just a car leak or something. And on the day went. He went to work, coaching basketball at Aberdeen High School, shaping young minds. Darrow lives close to the school, and it only took him about 5 minutes to get home and put in for the night. Except Darrow awoke in the middle of the night, and immediately he felt something was wrong. But again, oh, it's probably nothing. Another minute, and the smell of smoke comes to Darrow's nose. He opens his eyes, only to find he can't see. He gasps, but he can't breathe either. What's going on? He runs out of his room, his eyes watering, skin burning, flames are engulfing him. He's running, he's jumping out of the window. Bertie Darrow almost died in that house. When he turned around, he saw hell in front of him. Members of the jury, today it will be proven to you beyond any reasonable doubt that the defendant is guilty of first-degree arson and first-degree attempted murder. Beyond reasonable doubt does not mean beyond all doubt, because in life there will always be some doubt. But as long as there is no conceivable, believable, or reasonable doubt, then we've done our jobs. And members of the jury today, you will have no reasonable doubt in your minds, because revenge is the fire that consumes. Today, we will call up 2 witnesses that will show you 2 things. 1, the defendant was consumed by revenge. And 2, the defendant acted on his revenge. You will learn today that the rivalry between the defendant and Bertie Darrow is not a shot, going all the way back to when the defendant was caught robbing a pawn shop by Bertie Darrow, and the defendant went to prison for 3 years. Billy Huxley, a correctional officer who was in charge of the defendant when he was in jail, will tell you how the defendant chose to spend those 1,095 days in prison. Billy Huxley will show you how the revenge consumed the defendant. He heard death threats our defendant was making towards Bertie Darrow, including a drawing depicting this: a house on. The picture has a date in the top left corner, July 1st, the same month and day, but 3 years later, Bertie Darrow's house burned to the ground. And there's another date just below it, February 26, 2021, the same date that Bertie Darrow caught the defendant robbing that pawn shop all those years ago. Our second witness, Dr. Harley Blaze, a fire marshal who investigated the arson at Bertie Darrow's house, will show that the defendant wasn't just consumed with revenge. He used this revenge. She will show you that the gasoline found at the defendant when he was arrested was the same gasoline that was used to burn down Bertie Darrow's house. Today, you will see that the revenge that consumed the defendant fueled the fire that burned down Bertie Darrow's house. Find the defendant guilty, because revenge is a fire that consumes. Thank you.
Counsel, defense, whenever you're ready.
Yes, Your Honor. Your Honor, can I just confirm you can see and hear me all right?
You're perfectly visible and audible.
Great. She forged a fire for funds. $225,000. That's the number staring Bertie Darrow in the face. She's looking at her debt she can't pay. She's a high school gym coach, not a millionaire. She's consumed by debt, and it's only getting worse. Today you'll learn she tried to gamble her way out of it. Failed. She tried to get more loans, failed again. Now she was going to lose her home. Her desperation turned to deceit the day Darrow took a pen in one hand, signed an insurance policy. Today you'll see this policy wouldn't just protect, but pay Miss Darrow almost $1 million if her home was to go up in flames. Folks, you'll learn that on July 1st, 2024, Bertie Darrow was consumed by her need for funds and forged a fire at her home to deceive the insurance company, get a payout. She forged a fire for funds. So what does Miss Tanks have to do with it? Miss Tanks is sitting on trial because Miss Darrow forged a fire for funds and then used Miss Tanks as her scapegoat. And the state has fallen for Miss Darrow's lies. Today, as the state just told you, they've charged her with 2 things: first-degree arson and attempted first-degree murder. They gotta prove those claims to you beyond a reasonable doubt. Meaning, if there's a reasonable possibility that Miss Darrow, not Miss Tanks, forged that fire, then Miss Tanks isn't guilty. And while we're not obligated to, we're going to show you this case boils down to 2 things: a woman who needed funds and the fire she forged. Because Miss Tanks wasn't consumed by revenge. In fact, you'll learn, Miss Darrow was consumed by her need for funds. That's why the first fact you'll see from an insurance investigator is that Miss Darrow was $225,000 in debt. You'll see up close and personal that Miss Darrow's insurance policy would pay her almost $1 million if her home was to go up in flames. We'll show you who used that fuel, because the second fact you'll learn is the fire she forged. See, the fire was caused by paint thinner, not gasoline. Today, you'll actually hear from a hardware store worker who will show you receipts of Miss Darrow buying large amounts of highly flammable paint thinner just weeks before the fire, because she forged a fire for funds. Today, as Miss Tanks sits on trial, she's innocent unless these prosecutors prove otherwise. And Miss Tanks, well, Miss Darrow tried to use Miss Tanks as her get-out-of-jail-free card. But folks, this isn't a game of Monopoly. It's real life. So at the end of today's trial, when all the cards are on the table, it will be clear Miss Tanks wasn't fueled by revenge. That's why we'll ask you to find her not guilty, because the only person who was fueled by anything was Bertie Darrow forging a fire for funds. Thank you.
Thank you, counsel. Prosecution, please call your first witness whenever you're ready.
Yes, Your Honor. The prosecution calls Billy Huxley to the stand. Good evening. What is your name and the spelling of your last name for the record?
Well, my name is Billy Huxley, spelled Huxley. See, my great meemaw wanted me named after the famous country singer, Billy Joe Spears. She's a beaut, ain't she?
And what do you do for a living, Miss Huxley?
I'm a correctional officer because, as my third husband could never admit, I'm always correct.
So, how do you know the defendant in this case, Jimmie Tanks?
Well, I was working. I saw that Tanks was one of the inmates. Apparently, he was in for theft. But before that, I worked at the high school as a security guard, and Tanks was attending the school at the time.
Did you ever speak to the defendant when you were a correctional officer?
Yes, I learned he got caught robbing a store by a kid named Bertie Darrow, and I asked him what it was about.
What kind of things did Tanks say?
He made my ears bleed. I'm a peace-loving person, you see, but because he was threatening Bertie Darrow non-stop, talking about showing him what true fire looks like and making sure he suffers. Who we talk?
So, what did Tanks do in his free time?
Hank started hanging out with a guy named Alex Leonard, who was convicted for arson. Bless his heart.
How often did Tanks hang out with this Alex Leonard?
They hung out a lot closer than my pointer and my middle finger. Or, as you kids would say, they were tight. Every lunch period and most free time, they would hang out together. They started talking about some odd things.
Well, what effect did these odd things have on you?
Well, I was terrified and shocked, just like when my second husband tried to take all my money, because they sounded super ominous.
So, what kind of odd things were they saying?
I overheard that Leonard was talking about pouring the good stuff around the place when it's dark, and not my kind of good stuff, because then Tanks was talking about gasoline and paint thinners as possible things to use in a solution.
How many times did you see Tanks acting out in strange ways?
There were a couple more.
What can you tell me about one of those times?
Oh, right. One day I got assigned to Group C in the lunchroom.
Well, Group C, what does that mean?
There are different lunch groups, each with their own letters. Group C was Tank's group.
And how was Tanks acting odd?
All of a sudden, there was a fire in the serving area. It was quite large, and everyone was freaking out.
How did Tanks react?
Well, my mistake when I say everyone, because Tanks was just laughing the whole time, looking really out of place compared to everyone else. He also whispered to Leonard, saying, "Not bad for a trial run."
So, what other times did Tanks seem off?
Let's see, it was a group therapy session. Bunch of inmates got together, talked about overcoming issues in prison, boring stuff.
So, what else happened that time that made Tanks so strange?
Well, the prison therapist gave the inmates notepads. Everyone drew out their thoughts. None of the inmates seemed particularly excited about the idea, except for Tanks. He looked like my grandbaby in a candy shop.
What was Tanks doing?
He was drawing non-stop for a long time, not putting the notepad down, but eventually he stopped and went off to do something else.
What did you do then?
Wanted to go through his journal, but I just wanted to see what got him so worked up. But then I paused on a startling drawing of a two-story house on fire.
And if I showed you this drawing, would you be able to identify it?
Yes.
Please let the record reflect that I am screen sharing with the witness and opposing counsel only what is pre-marked for identification purposes only as proposed prosecution exhibit 10.
It shall so reflect.
What is this?
It's a picture of a drawing that Tanks made of a house on fire.
Is it a fair and accurate depiction?
Yes.
Has it been altered in any way?
No.
Your Honor, the people move to enter in evidence exhibit 10.
Any objections?
Yes, objection to lack of foundation on the dates on the drawing.
Can you elaborate?
We don't know whether or not these dates were written by Jimmie Tanks. Ms. Huxley can tell us if she knows that this was written by Jimmie Tanks or if she saw Jimmie Tanks writing it, but we, as a matter of fact, don't know for sure that these were written by Jimmie Tanks.
Your Honor, may I be heard?
Yes.
Your Honor, the witness saw Jimmie Tanks drawing this drawing, and she didn't see anyone else drawing on this journal. So it can't be possible for anyone else to have drawn these dates.
Response?
Your Honor, if we take a look here at this drawing, you can see that this drawing, the house, the fire, it's all drawn in this blue pen or pencil. And you can see that the dates are actually drawn in a different marker as well as the initials from Jimmie Tanks. So there's no guarantee whether or not these were written by Jimmie Tanks.
Defense, are you going to offer any evidence, say, to dispute that this was in fact not drawn by Jimmie Tanks? Do you plan on offering any evidence of that sort?
We plan on crossing on that.
Well, in that case, I think this is something for weight and not admissibility. Feel free to cross-examine on this, but I'm going to enter Exhibit 10.
Yes, Your Honor.
Your Honor, permission to publish by way of screen sharing to the jury, Exhibit 10.
Go for it. Yep.
Now, Ms. Huxley, what can you describe about this drawing, if anything?
Let's see. In the top left corner, there are a couple of dates and a drawing of a jail cell. One of the dates is, thanks, July 1st, but the year's unknown. And the other date, I believe, is February 26th. I'm so sorry, 2021.
So what did you do after you saw this drawing?
Well, I showed the page to the prison. Oh, I'm so sorry. I showed the page to the prison therapist.
Can you tell me about some other times Tank seemed strange?
Well, I'm a pretty darn good security guard, so I got promoted soon after the drawing incident. My first husband even reached back out, and I got assigned to a new prison group, so I never saw Tanks after that.
Thank you. Your Honor, I have no further questions.
Thank you. Cross-examination,
Yes, Your Honor. May I proceed?
whenever you're ready.
Good evening, Miss Huxley.
Good evening.
Now let's see if Jimmie Tanks ever gave you a reason to forge the truth. You used to be a high school security guard at Miss Tanks' school, right?
Yes.
And just like courtrooms, schools have rules, don't they?
They do.
Well, and that no drug usage rule, well, you broke it because you were addicted to marijuana.
Well, I did do some, but I'm not proud of it. But, a gal's gotta live.
And on one of your smoke breaks, a student, aka Miss Tanks, she caught you getting high, right?
She did. That was more on me. I should have hid myself a little better if I was gonna, as you said, break those rules.
And you desperately wanted Miss Tanks to mind her own business and shut up.
Well, I wouldn't say it personally just to Miss Tanks. I would have assumed anybody who saw me, but I think it's pretty much illegal to not report if you see somebody breaking those kinds of rules on school campus.
That's right, it's illegal to not report. She reported you to the principal, didn't she?
Yeah, I'm pretty sure you're obligated to, but yes.
You were fired on the spot?
I was. It was a pretty big rule breaking.
In fact, you weren't only fired, but you were charged with a misdemeanor for this pretty big rule breaking, weren't you?
I was. I got sent to this court rehabilitation program, but it worked out because that's where I met my second husband. But yes.
And that misdemeanor will be on your record for the rest of your life, right?
Yeah, I suppose.
And you were filled with anger about this, weren't you?
I'm pretty sure anybody would be mad if they got fired, but I gotta give it to Tanks because if it weren't for her, I wouldn't be here stone cold sober since September of 2020.
And you would say that all of this happened because that little narc, Jimmie Tanks, couldn't keep a secret, right?
I mean, yeah, I did think like that back then, but I don't give it to her personally now because, again, anybody would have done that.
Can I just get a yes or no to my question?
Oh, sorry about that. Yes.
Now, Miss Huxley, it's no secret you claimed a moment ago that Miss Tanks said some choice words while in jail. Let's take a moment and consider whether there's any proof Miss Tanks ever said these things. Or
Objection to argumentative.
Defense counsel, can you repeat the question just now?
This was my signpost. I just said, let's take a moment and consider whether there's any proof that Miss Tanks ever said these things.
All right. Prosecution, why is this argumentative?
Your Honor, the lawyer is testifying for the witness and stating an answer that the witness can answer with a question. If she could just simply rephrase her signpost and then ask a question, that would be fine with us.
So as the signpost is worded right now, with whether I think somewhere along the lines of let's talk about whether you're telling the truth or not. I think that's within what's allowed for cross-examination. So I'm going to overrule, but please feel free to re-raise if you feel like it gets argumentative.
Yes, Your Honor.
Your Honor, may I proceed? Now, Ms. Huxley, let's take a moment and consider whether there's any proof Ms. Tanks ever said these threats or if they might have been forged. You claim that she said, "One day I'll show Miss Darrow what true fire looks like, and I'll do whatever it takes to make sure Bertie Darrow suffers."
Yep, and I heard it loud and clear.
And after you supposedly heard these things, you must have documented them in a notebook, right?
No, I mean, as a security guard, you hear a lot of weird things, but I certainly documented it right here in the old noggin.
Right, you documented it right here in your old noggin for 3 whole years, didn't you?
I did, clear as day.
But surely you reported Miss Tanks' supposed threats to your supervisor, right?
Not at that exact moment, because again, as a security guard, you hear thousands of threats all the time, but there was an incident in the serving area where I did tell my supervisor.
Could I get a yes or no to my question?
Can you repeat the question? I'm so sorry.
Did you report these threats ever to your supervisor?
No, but I did report the serving area incident.
Now, Miss Huxley, jails have security cameras, right?
They do.
But ma'am, you didn't show us a single piece of security footage of Miss Tanks ever saying these threats, did you?
No, not all the guards have access to the security cameras.
Now, let's figure out if you would forge the truth to make sure Jimmie Tanks suffers. There's a possibility Miss Tanks can get sent to jail if she's convicted today, right?
Yeah, I'm pretty sure that's why we're here today, isn't it?
That's right, and if she gets convicted, Willow County Jail is a place where you have loads of connections at.
Well, I do have the connections, but just because you could use something doesn't mean you would use something. But yes.
You're one step ahead of me, Miss Huxley. And if Miss Tanks ended up at Willow County Jail, you could use these connections to make her life miserable.
Objection to relevance.
Can you elaborate, counsel?
Your Honor, we don't see how the witness using these connections to make Jimmie Tanks' life miserable is relevant to a case about arson.
Response?
Your Honor, the witness just testified that Jimmie Tanks caught her smoking and caused her to go to jail. So this goes to her credibility and her bias against Jimmie Tanks.
Prosecution, you have last word.
Yes, Your Honor. Again, we don't see how this goes to credibility or bias in any way. She's just simply asking if the witness has connections, and that is not relevant to this case.
I don't think the particular question was asking for connections. I do believe this line of questioning goes towards credibility or bias, and that's always relevant. So I'm going to overrule that for now.
Yes.
Your Honor, may I proceed?
Yes.
Now, Ms. Huxley, I'm going to ask my question again.
Right on.
If Miss Tanks ended up at Willow County Jail, you could use these connections to make her life miserable.
That doesn't mean I would. I'm way too busy. I'm actually planning my eldest daughter's wedding. So yes, I could, but that doesn't mean I would.
Right, you could make that narc Jimmie Tanks' life miserable.
Yes, but that doesn't mean I would. I called him a narc way back when. I don't have time to get involved in all that high school drama anymore.
Now, Ms. Huxley, you're aware that you could have edited your affidavit up until today's court case, right?
Yeah.
And you're saying that you only called Jimmie Tanks a narc way back when?
I mean, I still feel that way now, but I don't really care. Again, it's a high school drama at this point.
Now, you say that you don't really care, but you're actively helping today's prosecutors, aren't you?
Well, yeah, I witnessed some pretty crazy stuff.
Now, to be clear, you weren't told to be here by Judge Jang.
No. Pleasure to meet you today, Mr. Zhang.
And Mr. Blanar didn't force you to take the stand, right?
Well, I would hope not. Being forced is pretty scary.
That's right. Being forced is really scary. And that's why you volunteered to testify against the woman you think deserves to be put in her place, right?
Well, I mean, yeah, if you saw somebody making crazy threats too, you would. Again, it's not personally to Tanks, it's just what I saw, what I witnessed.
That's a yes to my question, right?
Yep.
Thank you, Miss Huxley. Nothing further, Your Honor.
Alrighty.
Thank you, counsel. Any redirect?
No, Your Honor. We simply ask that this witness step down.
All right, Miss Huxley, you're excused. Plaintiff,
Bye, y'all.
not plaintiff, sorry, prosecution, call your second witness.
Yes, Your Honor. At this time, the prosecution calls Dr. Harley Blaze to the stand. May I proceed? Good
Go ahead.
evening, Dr. Blaze. May you please state your first name and the spelling of your last name for the record?
Good evening. My name is Dr. Harley Blaze, and my last name is spelled Blaze.
What's your occupation, Dr. Blaze?
Well, I was actually just promoted last year from lead fire investigator to now fire marshal, but my day-to-day work is usually just investigating fires and the causes of them.
Well, congratulations on your promotion. So, what degrees do you have that allow you to be a fire investigator?
I have all 3 certifications from the National Association of Fire Investigators. I also have international certification from the International Board of Arson Investigators.
So, that's a lot of certifications, Dr. Blaze. Do you have any schooling?
Yes, I do. I received schooling from the University of Wisconsin, where I received a doctoral degree in chemistry. I also received an associate's in fire science, and
Well, Dr. Blaze, do you have any experience testifying as an expert witness in court?
yes, I have numerous.
Do you normally prepare conclusions and reports?
Yes, and I was able to prepare a report today and reach a conclusion within a reasonable degree of scientific certainty.
Dr. Blaze, now that we've discussed your technical background, let's begin at the start of your investigation. What is the first step you took today in coming to your conclusion?
I first received a call from the Tilly Fire Department that there was a fire at Bertie Darrow's house, so I rushed straight to the scene.
What did you do when you arrived on the scene?
Well, I did what I always do and started looking for some burn patterns, or in simpler terms, fire patterns.
Well, Dr. Blaze, I am surely no expert in fire science, so can you please tell us what burn patterns are exactly?
Of course, Miss Curry. Burn patterns are identifiable shapes that are formed when materials are exposed to fire.
And how are they helpful when investigating the causes of fires?
They tell fire marshals like myself the origin of the fire and the possible causes of them.
If I showed you a picture of one of these burn patterns, would you be able to remember it?
Of course.
Your Honor, please let the record reflect that I'm screen sharing with the witness and opposing counsel only what is pre-marked for identification purposes as proposed prosecution exhibit 6.
It does so reflect.
What is this?
This is the burn pattern I observed from Darrow's residence.
And is it a fair and accurate depiction of that burn pattern as when you last saw it on July 1st, 2024 at Bertie Darrow's home?
Yes, Miss Curry.
Your Honor, at this time, the prosecution offers Exhibit 6 into evidence as prosecution Exhibit 6.
Objections?
No objection, Your Honor.
So entered.
Yes, Your Honor. Dr. Blaze, may you please outline this burn pattern for us?
Of course. As you can see here, it is now outlined in red. This shows that it is a puddle-shaped burn pattern.
Well, what are puddle-shaped burn patterns?
Puddle-shaped burn patterns tell us that there is the presence of ignitable liquid. You can think of it as pouring water on the floor. There is no start or end point. Just like this puddle-shaped burn pattern, it just forms a puddle. Therefore, we can tell that an ignitable liquid was formed and used to start the fire. This actually may have been gasoline.
Well, where did you find these puddle-shaped burn patterns at?
I found them leading up the back walkway to the backyard.
And how are they helpful in coming to your conclusion today?
Well, they told me that this fire could have been caused intentionally and by an ignitable liquid that may have been gasoline.
Now, Dr. Blaze, now that we've discussed the origin of the fire, I want to talk about what you did after that. What did you do immediately after investigating the origin of the fire?
Ms. Curry, I talked to the homeowner, Bertie Darrow, which is standard in any procedure.
And how did speaking with him affect your investigation?
Well, I talked to Bertie Darrow, and after that, I rushed straight to Tank's house.
What did Mr. Darrow tell you?
He was telling me some interesting things about Jimmie Tanks, how he sent him to jail just a couple years ago, and how he had it out for him after that.
Did he tell him anything else that infected your investigation?
Yes, he also told me that there was a shadowy figure outside his house. Therefore, I went to Jimmie Tanks' house right after.
What did you see when you arrived to Jimmie Tank's house?
Miss Curry, when I arrived at Jimmie Tanks' house, I saw him having a red plastic container in his hands and pouring some type of liquid out of it. I got the very distinctive smell like gasoline.
What did you do after witnessing this and having that distinctive smell of gasoline, Dr. Blaze?
I arrested Jimmie Tanks immediately since I had probable cause. From what Bertie Darrow had told me and what I had just witnessed, it was essential, and I took the two containers he had into evidence.
Did you test the substance within these containers?
Of course, and this was later confirmed to be gasoline, which may have been used to start the fire the night of July 1st at Bertie Darrow's house.
Now, Dr. Blaze, I want to focus on something else that you found during your investigation. Earlier, you mentioned burn patterns and fire debris samples. So, what exactly did you do with these?
Well, I used these samples in order to test them further using a test called the GCMS test, which has a near 100% accuracy rate. I wouldn't use anything less.
GCMS test, Dr. Blaze. What exactly is this?
Well, Ms. Curry, it's a very long and complicated process. I actually have a little slideshow I use to teach new recruits about this, and I actually applied it to this case today.
Your Honor, please let the record reflect that I am screen sharing a demonstrative that has been previously shared with opposing counsel.
Sounds good.
Now, Dr. Blaze, let's break this process down step by step. What is the first thing that you did in this process?
The first step I always take is collecting the fire debris samples to run through the test. In this case, I tested 4 samples, 1 from the outer walls, and then 3 from different pour patterns I observed.
What do you do with these samples that you collect?
I run these through the GCMS test, and the first portion is the GC, or gas chromatography portion of the test.
What happens during this first step, then?
Well, it's also very intricate, but we can think of it as the TSA line. You know how you have your water in your bags and they make you take it out? It's just like the GC portion of the test, taking out those volatile components in order to send it through the MS portion.
Well, there's a second portion. So what happens during that portion of the test, Dr. Blaze?
Well, Ms. Curry, during the MS or mass spectrometry portion of the test, we send those volatile components through the MS portion. You can think of it as your bag going through a TSA detector. First, you just see the bag, but when you actually run it through the detector, you see the components within it. This is just like sending those volatile components through because they identify the third dimension.
Dr. Blaze, third dimension, what is that?
This is the materials found from within the sample taken.
Now, Dr. Blaze, what did your results find from this GCMS test?
It found the material used to be gasoline, and I found no other traces of ignitable liquids.
Thank you, Dr. Blaze. So, what did you do immediately after conducting this GCMS test?
Immediately after conducting it, I completed a visual comparison of a regular gasoline sample to one of the fire debris samples I took.
And if I showed you this visual representation, would you be able to remember it?
Of course.
Your Honor, please let the record reflect that I'm screen sharing with the witness and opposing counsel only what has been pre-marked for identification purposes as proposed prosecution exhibit 7.
So reflected.
What is this, Dr. Blaze?
This is the visual comparison I conducted of the regular gasoline sample and the fire debris sample from Bertie Darrow's residence.
And is this visual comparison a fair and accurate representation of when you last made it?
Yes, it is.
Has it been altered in any way?
No, it not.
Your Honor, at this time, the prosecution offers Exhibit 7 into evidence as Prosecution Exhibit 7.
Any objections?
No objections, Your Honor.
The entry.
Your Honor, at this, please let the reflect that I'm screen sharing a demonstrative that has been pre-shared with opposing counsel.
Yep.
Dr. Blaze, what are these two graphs comparing?
This is comparing a regular gasoline sample and a fire debris sample I took from Bertie Darrow's residence.
Well, to break this up a bit, what exactly is this first graph representing?
The first graph represents the chromatograph of the total ion current for the regular gasoline sample.
What is the second graph representing?
The second graph represents the chromatograph of the total ion current for the fire debris sample found at Bertie Darrow's house.
Dr. Blaze, what similarities can you show us between these two graphs?
Well, Ms. Curry, there's numerous, but first let's start at the 5-minute mark. As you can see here is about this high. Now, if we look at the other graph on the same interval, it's the exact same height. They're identical.
What other comparisons can you show us?
Again, there's numerous, but now let's look at the 25 to 30-minute interval. As you can see is about this low. Now, if we look at the other graph on the same interval, you can see is the exact same height again. This is a perfect match of the two samples.
Dr. Blaze, because of these similarities, what can you conclude from these two graphs?
I can conclude that gasoline was present within this fire and used to set it.
Now, Dr. Blaze, after going through this investigation, what were your final conclusions?
My final conclusions is that the fire at Bertie Darrow's house the night of July 1st, 2024 was set intentionally using gasoline.
And who was the only person that you found during your investigation with access to gasoline?
Jimmie Tanks.
And who was the only person during your investigation that you found with the need for revenge during your investigation?
This was Jimmie Tanks again.
Objection. Lack of foundation. May I be heard?
Yes.
Your Honor, the Miss Blaze just said that Jimmie Tanks was the only person in her investigation who had a need for revenge. Your Honor, if Miss Blaze talked to Jimmie Tanks and was able to confirm with Jimmie Tanks that he in fact wanted revenge, we'd be fine with that. But Your Honor, can I proffer?
Yes.
Your Honor, this witness is currently taking Bertie Darrow's word for the truth of the matter asserted and referring back to that word as to say that's why Jimmie Tanks wanted revenge, because it came from Bertie Darrow.
Response?
Yes, Your Honor. Your Honor, Dr. Blaze used Bertie Darrow's testimony to form her conclusion today. This statement is simply just as part of her conclusion that she found.
Your Honor, may I be heard? Your Honor, I'd actually like to change my objection to speculation because the witness is currently speculating as to Miss Tanks' mindset that she wanted revenge.
Got it. Can I just hear the testimony from the witness again? Ms. Curry, can you remind the court on what your question was as well?
Yes, Your Honor. Dr. Blaze, who was the only person that you found with want for revenge during your investigation?
Jimmie Tanks.
All right. Response to the Ms. Curry, response to the speculation objection.
Yes, Your Honor. Dr. Blaze isn't going into the mindset of Jimmie Tanks. She is simply discussing what she heard from Bertie Darrow, what she used to come to her conclusion today. This is the conclusion that Dr. Blaze came to.
Your Honor, may I be heard?
Yes, final word.
Your Honor, the specific wording of the witness agreeing to the question that Jimmie Tanks wanted revenge is speculation because this witness does not know. She cannot dive into the mindset of Jimmie Tanks as to whether or not he wanted revenge. That specific comment is extremely speculative, and Your Honor, it's not admissible.
Just to make sure, Dr. Blaze never interviewed Miss Tanks, correct?
Correct, Your Honor.
All right. And on that, I am going to sustain the objection. I do believe for Dr. Blaze to say Jimmie Tanks had a sense of wanted some revenge, well, lacks foundation, but also is delving into the mindset. Ms. Curry, feel free to rephrase that question.
Yes, Your Honor.
Your Honor, motion to strike that testimony.
The answer is stricken.
Yes, Your Honor.
Sorry. Dr. Blaze, after speaking with Bertie Darrow, what exactly did she learn about Mr. Tanks?
I learned that Mr. Tanks was after Bertie Darrow and maybe had motive to set the fire at Bertie Darrow's house that night.
Thank you. No further questions, Your Honor.
All right. Cross-examination.
Yes, Your Honor. Hello, Dr. Blaze.
Good evening.
Let's see if your investigation covered all the bases. You showed us a moment ago a visual aid for that GCMS test you ran, right?
Yes.
Ma'am, I want to show the jury another visual aid. Let's say I take this water bottle. I only look at the surface area, top, bottom, but I never unscrew the lid. It's reasonable to say I couldn't know what liquid is inside. Correct?
Yes.
Similarly, I couldn't know what water or soda could be in the water bottle because I didn't check the inside, right?
Yes, however, with some substances, you can smell them. Like gasoline, it has a very distinctive smell, so you're able to smell the aroma and able to conclude what substance it is with further testing later on.
Not my question. Redirecting you back to my question, ma'am. I couldn't know what liquid is inside this water bottle because I didn't check inside, right?
No, you cannot.
Now, similarly, when you investigated Miss Darrow's house, you only gathered evidence from the perimeter of the building.
I did test one of the samples on the wall, but yes, I gathered from the pore patterns I observed.
Ma'am, you just said you tested from the wall. Let's be clear, that was an exterior wall.
Yes.
You also ran tests on the backyard.
Yes, I did.
However, you never went inside the house and gathered samples.
No, I did not. That is not where I found any pore patterns or identifiable liquid shapes that would lead me to believe that there would be further testing needed to be done there.
Ma'am, you didn't even gather samples from the interior. So let's correct what you just said. You weren't able to run tests on that evidence, were you?
No, I was not.
Doctor, you can't say, based off the test you never ran, if there was, for example, paint thinner on the interior walls, correct?
No, I cannot.
And a moment ago, you showed us that visual aid, and you actually checked a big fat X in that box showing possibilities, correct?
Yes, I did. I found no other ignitable liquids from the pore patterns I took samples from.
Exactly. Let's talk about the pore patterns, or rather the samples you never tested, because you never tested the interior of Miss Bertie Darrow's house, like we already established, correct?
No, I did not test the interior.
And because of that, you can't say with 100% certainty if that other possibilities exist, right?
Yes, I can only tell you the samples I took.
So we're going to actually check a big old fat check mark next to other possibilities. Now, ma'am, you also said a moment ago that Miss Tanks was the only suspect you found had a motive to hurt Miss Darrow? Do I have that right?
Yes.
Ma'am, let me make sure I got this right, because Miss Tanks was the only suspect you had in your investigation.
Yes, all the evidence led to her, therefore she was the only suspect.
It's reasonable to say that if I turn my back on you, focus solely on this white wall, I might miss something you do, right?
Yes.
Let's see if you missed the real person who could have forged this fire because you were focusing on the wrong things. It's true Miss Darrow had almost $1 million insurance policy.
Objection, Your Honor.
On what grounds?
Assuming facts not in evidence, may I be heard?
Yes.
Your Honor, this witness never testified as to knowing anything about an insurance policy from Bertie Darrow.
Response?
Your Honor, this is not facts not in evidence, because that would work if Miss Harley Blaze only knew something because of an exhibit. Your Honor, can I proffer?
Yes.
I'm currently laying the foundation as to how Dr. Blaze knows about this $1 million insurance policy, and she knows this because she specifically investigated it.
All right, I'm going to overrule that for now. If you feel like foundation is not being laid in the next few questions, and this is still please feel free to re-raise that objection then.
Yes, Your Honor.
Miss Blaze, you know from your investigation, Miss Darrow had almost $1 million insurance policy.
Yes.
And if her home ever burned down, she would get that money.
Yes, only do it to extenuating causes.
But you didn't look into the possibility that Miss Darrow set her own house on fire for funds, did you?
I did not find that Miss Darrow would have the possibility or the motive to burn down her own house.
But you didn't even look into her bank records to see if she was in debt. Do I have that right?
No, I did not, because all the evidence I found led to Jimmie Tanks.
Okay, so you can't tell these jurors that she had a gambling addiction.
No.
You can't tell these jurors if Miss Darrow was in debt because she gambled.
No, I can tell you who had a motive against Bertie Darrow, though, and that was Jimmie Tanks.
Ma'am, you can't tell the jurors if Miss Darrow had a motive to forge that fire for funds because you never looked into the funds. Do I have that right?
Yes.
Your Honor, I have no further questions.
Any redirect?
Yes, Your Honor. Dr. Blaze, what were the causes of this fire that you investigated?
I was able to reach within a reasonable degree of scientific certainty that gasoline was the cause of this fire, and the only person I found to have access to gasoline in my investigation was Jimmie Tanks.
Thank you. No further questions, Your Honor.
Any recross based on that redirect?
No, Your Honor.
All right.
This witness can be excused.
Perfect, Dr. Blaze, you are excused. I do think we're doing pretty well on time. Why don't we take, well, plaintiff, do you have prosecution, do you have any other witnesses to call?
No, Your Honor. At this time, the prosecution rests its case in chief.
Perfect. All right. Why don't we take both sides? We want a 5-minute break, 10-minute break. What are you guys thinking?
A 7-minute break is okay with prosecution, Your Honor.
We'll do a 7-minute break. We'll come back at 7:07 my time.
Great, we'll set our clocks.
All right. Let's move on to defense case in chief. Defense, please call your first witness whenever you're ready.
Yes, Your Honor. The defense would like to call Mr. Jordan Parks to the stand.
Hi, everybody. Can you guys see me all right?
We can't see you right now, Mr.
Oh dear. Here, let me get this camera on. Can you guys see me now? Am I a bit too close?
Yes, we can see you now.
Oh, perfect. Sorry, I don't know how to do these. Them youngsters call it the Zoom call, but I appreciate you guys having me here tonight.
Likewise, Mr. Parks, we appreciate you working out the funky thing that is Zoom today. Good evening. Could you please introduce yourself to the members of the jury?
Sure, the name's Jordan Parks. Just a regular guy running a hardware store. Nothing fancy. I apologize for the background. It's not as nice as some of you have it. I had to go find a break room to do this Zoom call in.
No worries, Mr. Parks. Now, where are you from?
Oh, I'm from Mountain Brooks, back down south in Alabama. Born and raised. It got a little too crowded and expensive out there. So I packed up and moved somewhere quieter.
What do you do for a living?
I help run a store called Nuts and Bolts. It's the kind of place where folks can stop in, not just for supplies, but for advice, whether it's fixing a leaky pipe or building something from scratch. I like to help people out.
Do you know why you're in court today?
Oh, I helped two people, a woman named Jimmie Tanks and another person called Bertie Darrow at my store. Turns out Darrow's house burned down. So reckon I'm here to tell y'all what I know about that.
Now, you mentioned Jimmie Tanks. Could you tell us a bit more about Jimmie Tanks?
Of course, ma'am. On June 2nd, 2024, when Mr. Tanks, they came in looking for equipment to go camping in the woods. That's not my cup of tea, but who am I to judge?
Now, why do you say that she was going camping?
They needed some cloth, some rope, gas, and then an American flag.
Now, let's see if Miss Darrow had the fuel to forge a fire. When was the first time you saw Miss Darrow?
It was June 25th, 2024. The day I actually got back, Bertie came in looking for painting supplies.
What type of painting supplies?
It was some paint and then paint thinner. A lot of paint thinner.
Now, why do you say it was a lot of paint thinner?
Oh, they bought a way more paint thinner than paint, which is a little strange. Thinner is flammable, so we keep it locked up separate from everything else in the store.
Did this concern you?
Yes, it did, because it was unusual to see a folk purchase a large amount of paint thinner. Even some folks who've worked on painting large houses don't buy this much thinner.
On what grounds?
To improper opinion, may I be heard?
Yes.
Your Honor, this witness only works at a hardware store. He knows nothing about how flammable, or he knows nothing about how buying too much paint thinner or the consequences of that.
Response?
Your Honor, just as you might go to Home Depot to ask which swatch of paint to buy for your house or how much paint you should buy based on how large your house is, Mr. Parks works at a hardware store just like Home Depot, so he should be qualified to make those opinions.
Ms. Small, what exactly is the testimony elicited?
The testimony specifically is that, I believe if Mr. Parks could repeat it, just that people who are working on large properties didn't buy as much paint thinner as Miss Darrow.
Ms. Curry, is that your understanding of the allegedly offending testimony, or?
Yes, Your Honor.
In that case, I do think I think within Mr. Parks' lay witness perception to testify to say the basic operations and basic knowledge he acquires through operating his shop. However, Ms. Curry, feel free to re-raise that if Mr. Parks is going to more specialized knowledge on any of the goods that he's selling. So overruled for now.
Yes, Your Honor.
Your Honor, may I proceed? Now, Mr. Parks, you mentioned that it concerned you that Bertie Darrow purchased a lot of paint there. Why was that?
Well, like I was saying earlier, even folks who work on painting large houses don't buy this much thinner. It is unusual to see somebody purchase a large amount of paint thinner from my store.
Was there anything else that stood out to you about Darrow's visit that night?
Well, Darrow was short on funds, $1.75 if I remember right. I covered it. It wasn't much. It just felt like the right thing to do. I mean, they had this really rusty looking car as well.
Mr. Parks, did you have any other interactions with Jimmie Tanks or Bertie Darrow?
Yeah, Jimmie Tanks came by the 1st of July, very late at night.
What happened once Jimmie showed up?
Oh, Jimmie ran in like those gazelles we have down south. They were breathing and they were kind of complaining a little bit.
What did Jimmie need?
They needed some gasoline, but we ran out, so I told and I gave Jimmie some directions to go to another store as soon as I finished up inventory.
Did Jimmie purchase anything else?
Oh yes, Jimmie bought just a small pack of gum and then ran off.
Mr. Parks, does Nuts and Bolts record the purchases of their customers?
Yes, ma'am, we do.
Your Honor, let the record reflect that the defense will now be displaying what's been pre-marked as Exhibit 8B.
Got it.
Mr. Parks, is this a fair and accurate copy of the receipt from your purchase with your interactions with Miss Bertie Darrow and Mr. Tanks?
Yes, these match what I remember from their visits.
Your Honor, the defense now moves to admit Exhibit 8B into evidence.
Any objections on this?
Yes, Your Honor. Objection to hearsay.
All right, response.
Under 8036, this is an exception to hearsay under record of a regularly recorded activity. This is a receipt that's been regularly recorded as a business practice at Nuts and Bolts.
Your Honor,
Respond. Yes.
Your Honor, the defense has not met all 5 prongs for 8036.
Can you point me to which prongs they have not met?
Yes, Your Honor. In order for this receipt to qualify as a regularly conducted business activity, the record must be made near or by or from information transmitted by someone with knowledge. The record was kept in course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit, making the record was a regular practice of the activity. And all these conditions show the testimony of the custodian or another qualified witness. However, Your Honor, the defense has failed to meet 3 of these prongs: that the record was kept safe and sound, and that the record is a regularly practiced activity of this company.
Ms. Smollett, response to those grounds?
Your Honor, Mr. Parks can testify whether or not it's been safe and sound, but I just asked Mr. Parks, does Nuts and Bolts record the purchases of their customers? And to that he answered yes. So we did prove that it's a practice of a regularly conducted practice.
What about, I'm a little bit more concerned on D. Who's the custodian here or the qualified witness? Have we laid foundation on that yet?
Mr. Parks keeps these receipts and he was there for that purchase, so I think it's qualified to say that he's the custodian of this record.
Has that been laid onto the record yet, though?
Well, Mr. Parks testified to taking that order from Miss Bertie Darrow.
I'm going to sustain for now. I just think maybe ask 1 or 2 more foundational questions if you're trying to enter this under 8036. And I don't know if these, but I just want to hear a little bit more foundation before that's done.
Yes, Your Honor.
Your Honor,
Mr. Parks.
Sorry. Your Honor, may I move to strike?
I'll strike it for now, but if it's entered, then so I'll strike it for now. Yes.
Your Honor, may I proceed? And Mr. Parks, did you take down this receipt?
Yes, I did.
Your Honor, the defense now moves Exhibit 8B into evidence.
Objections?
No, Your Honor.
All right. Seeing there's no objections, this is entered. The previous testimony laying foundation for this exhibit is back onto the record. You may proceed.
Yes, Your Honor. Now, Mr. Parks, comparing these two customers, what differed from when you talked to them?
Well, I mean, they're both just customers at my humble little store. Jimmie seemed like an outdoorsy gal, though, while Bertie Darrow, Lord, with that paint in her, seemed like she might need to do some returns. I'd be happy to take them for her.
Thank you, Mr. Parks. No further questions, Your Honor.
Thank you, ma'am. Have a great day.
You too.
All right. Cross-examination.
Yes, Your Honor. Good evening, Mr. Parks.
Evening. How are you doing today, young lady?
I'm good, Mr. Parks. Now, on direct examination, you just mentioned that it's unusual for people with large houses to purchase so much paint thinner, correct?
Yes, I did.
However, you had just been employed by Nuts and Bolts. Isn't that right?
Oh, yes, but during our safety and during the time I had spent before that interaction, I had plenty of advice on selling things, on knowing the right quantities of things, normal quantities. But that's a yes to your question, maybe.
So you had advice, but you never got any real experience with people purchasing so much paint thinner, have you?
No, I got that advice from people who have worked before me, though.
So that's yes to my question, Mr. Tanks?
Oh, sorry, lady. Was that answer not quite to the liking? I'll make sure to keep them shorter next time for you if that's easier for you.
So that's yes to my question, correct?
Oh, yes, yes.
Now, you also mentioned that Bertie Darrow had purchased 2 cans of paint thinner, correct?
Correct, I did.
But he also left with the fire extinguisher, didn't he?
Yes, along with some painting supplies.
Yes. So now, Ms. Parks, let's talk about your job a little bit. You also mentioned on direct examination that you work at Nuts and Bolts.
Oh, yes. I started working when my boss, Mr. Mason, went up and he had this help wanted sign outside the store, and I figured I could help out a bit around the shop. Yes, lady.
And this is the only hardware store in town between Willow and Little Hamlet, correct?
That is correct.
Now, on your first day there, Jimmie Tanks was your first customer.
Oh, yes.
And he had come in looking for gasoline, supposedly for a camping trip, wasn't he?
Yes, on that day. And he ended up buying some rope, cloth, gas, and then an American flag.
But to your knowledge, there weren't any campsites nearby, were there?
No, which is why I assumed they were probably driving out of town to go to a different campsite.
Well, that would have to be quite far out of town because it's a 2.5-hour drive between Willow and Little Hamlet, correct?
Oh, yes. It takes quite a while, and sometimes with traffic, it could get even worse.
And so in between those two areas, you didn't know of any campsites, did you?
I didn't, but there could very well have been one.
There could have been one. Yes, that's it?
Yes.
You can only assume this.
Yes, I don't go out camping. Not my cup of tea.
Now, Ms. Parks, I would direct you towards the events that transpired the night that Bertie Darrow's home burned down. Mr. Tanks had came back on July 1st around 10:30, yes?
Yes, that's when they came into my store all panting, breathing heavily, and mumbling all sorts of things.
Well, yes, exactly. He had came back in this time frantically looking for gasoline. But to your knowledge, there was no more gasoline left, was there?
Yeah, and when I told him, he sort of took my arm a bit and just sort of asked me to please check again. But I told him we were out for the day, but there's this other hardware store that I'm sure can help you out.
And this other hardware store was in Little Hamlet?
Yes, that is my understanding.
You then claim that he rushed in this direction.
No, well, he left the store and then I saw a car going in that direction. Yes.
Mr. Parks, you're saying that you had seen a car going in that direction towards Little Hamlet?
It was going towards Willow, actually. It was a sort of, it matched what I remember from Jimmie Tanks's visits, and it had this sort of weird looking headlight that was a bit busted.
So you had never seen a car going in the direction of Willow that looked like the defendants. Going in the direction of Little Hamlet that looked like the defendants, did you?
No.
So let's talk about what happened after you thought that the defendant had left. You went to the back shed to see if there was a spare gas tank, correct?
Yes, and after that young lady Tanks left, I found that we did still have an extra one that may have been sitting in the shed outside the store.
Well, when you got to the shed, that padlock was unlatched, wasn't it?
Oh, yes, and I thought that was strange because, well, don't let this gray hair fool you. I am no fool. I double-checked and padlocked it and everything before I went out and checked again.
Well, you went and checked again and that padlock was unlatched and you had a missing spare tank of gasoline.
Oh, yes, yes.
Now, Mr. Parks, let's talk about how the defendant is the one who actually forged his revenge. Let's talk about what you saw after the missing gasoline. 5 minutes later, you had seen a car that looked very similar to Jimmie's heading in the direction of Willow, didn't you?
Yes, that was the car with the busted, weird-looking headlight I was just talking about.
And Willow is where the fire occurred, isn't it?
To my understanding, yes.
So, to be clear, you saw a car that looked just like the defendant's, heading towards Willow, where the fire occurred right after finding a missing tank of gasoline.
Yes, you have that right, ma'am.
Now, Ms. Parks, let's just clarify your timeline a bit. Your Honor, Your Honor, please let the record reflect that I'm screen sharing a demonstrative that has been pre-shared with opposing counsel already.
Sounds good.
Now, Mr. Parks, Mr. Tanks came into the store around 10:30 p.m., yes?
Yes.
Then he left at 10:40.
Yes.
Now, you live in Willow, don't you?
I do. I've lived there for quite a while. I moved out from Little Hamlet once all that craziness started happening. Could you believe that? That type of stuff going on down there? But yes, I do reside in Willow.
And that night, it had took you 1 hour and 30 minutes to get home, correct?
Yes, that is correct.
But this arrival time included a 15-minute delay, as well as a 20-minute delay for you to stop and watch fireworks.
Correct. There was also a little car accident on the way home, which was also why Jimmie Tanks was telling me about when they went into my store, which caused a bit of a delay.
And that car accident caused that 15-minute delay.
That is correct, ma'am.
So, Ms. Parks, considering your drive to Willow, if the defendant left the store around 10:40 and went directly to Willow, he would have been able to make it there within 1 hour and 15 minutes without any stops before midnight, wouldn't he?
Yes, that is correct.
No further questions, Your Honor.
Thank you, lady. Have a nice day now.
You too, Mr. Parks.
Thank you.
Any redirect?
No redirect, Your Honor. May Mr. Parks get back to his job?
Of course. Thank you, Mr. Parks.
Thank you.
All right. Defense, please call your second witness whenever you're ready.
Yes, Your Honor. We call M. Reynolds to the stand. Hello.
Good evening.
Can you tell the court your first and last name?
Sure thing. My name's Mackenzie Reynolds.
What do you do for a living, Miss Reynolds?
I'm an insurance inspector down at the Tilly Insurance Group.
You just told us you're an insurance inspector. What's your educational background?
Yes, so I have two areas of expertise. I want to say one is in fire investigation, and the other is actually in structural failure investigations. And then I have a Master of Science in Fire and Safety Engineering.
What type of fire investigation do you have experience in?
So for 20 years, I investigated fires and arson-related crimes on the police force. My daughter Jenny, she likes to call me Sherlock Holmes, just with a fewer mysteries and more fire extinguishers.
Let's take a moment and investigate your involvement in this case. Why are you in court today?
I'm here to talk about the potential financial needs of Miss Darrow, and I also investigated whether the fire at Bertie Darrow's residence was deliberate or accidental.
What did you investigate?
So the first thing I reviewed is the physical evidence, and then I also conducted an inspection at Bertie Darrow's house, and then a gas chromatography mass spectrometry test.
All right, and how did you reach your conclusion on this case?
I used sufficient facts and data in a method known as the double P method.
Let's see if the double P method might point to Miss Darrow forging a fire for funds. What do those two P's stand for?
They stand for property and then patterns.
What was the first P for?
Yes, so that P, property, was when I actually reviewed Miss Darrow's insurance policy and financial records to just verify her claims.
Stating for the record will now be screen sharing Exhibit 1, Miss Darrow's insurance policy, and Exhibit 3, Miss Darrow's financial records on screen. Can you tell me what these are?
Yes, so if I'm looking at those images, the first one is Miss Darrow's insurance policy, and then the second one is Miss Darrow's financial records. And both documents don't seem to have changed for me.
Is it common practice for companies to maintain records of their clients?
Yes, so to my knowledge, this is common practice.
Your Honor, the defense offers Exhibit 1 and 3 in evidence.
Any objections to either of these exhibits?
Yes, Your Honor. Objection to hearsay on both of these exhibits.
All right, how do you respond, defense?
Your Honor, these statements, or rather these exhibits, are admissible under Rule 703, basis of an expert opinion. These exhibits highlight the testimony that led Miss Reynolds to her conclusion on this case. And not only does 703 apply here, but if we look back at case law Thompson v. Cameron, 2005, it tells us that hearsay in the form that leads the expert to conclude her specific conclusions on the case is admissible.
Response to the grounds of 703, prosecution.
Your Honor, also pursuant to Thompson v. Cameron, experts are not allowed to be used as conduits for hearsay. And in this case, no foundation has been laid that the witness used these exhibits to reach her investigation or her conclusion in her investigation.
Your Honor,
Defense.
may I be heard?
Can you proffer for me on how these exhibits are going to help for Miss Reynolds' conclusion?
Yes, Your Honor. We're actually in the process of laying the foundation. Once these exhibits are admitted, Miss Reynolds will go on to discuss how Exhibits 1 and 3 allowed her to conclude that there are other reasonable possibilities for the cause of this fire, such as Miss Darrow potentially forging the fire for funds because she was in debt. And Your Honor, because of Exhibits 1 and 3, she was able to form this conclusion, which under Rule 703, basis of an expert opinion, is admissible.
All right, so prosecution, is your only issue with these being entered being that they might serve as conduit to hearsay? Is that your concern?
Yes, Your That's right.
In that case, I'm gonna let these in. However, by the end of this witness's testimony, if you feel like these exhibits, while they haven't been used to directly support Ms. Reynolds' conclusions, please re-raise this objection, and then we'll review it at that point. For now, they're in.
Yes.
Your Honor, can we go ahead and publish those exhibits to the members of the jury?
Yes, go for it.
Miss Reynolds, can you tell us why these exhibits are important to you?
As my kids would say, it was the cherry on top of their sundae, but really, it helped me conclude that Miss Darrow was in debt, and she did owe $225,000 to the bank.
Did you find anything else concerning the funds?
I learned that Miss Darrow would actually receive $900,000, allowing me to conclude that she did need the funds.
Let's talk about the second P. What did the pattern show you?
Yes, I observed and tested something called burn patterns. And this is really interesting to me, but these burn patterns refer to distinctive marks or shapes left on materials like wood or metal after they've been exposed to heat.
And did you test those materials?
I did. I tested them to determine if that fire was intentionally set. The burn patterns were largely concentrated on the walls in the front porch, indicating the use of some ignitable liquid.
You just said ignitable liquid. Were you able to identify that specific liquid?
Yes, so through my GCMS test, I confirmed it was paint thinner.
Could you walk us through how you were able to test that it was paint thinner?
I ran something called a mass spectrometry test to identify if it was paint thinner.
What's a mass spectrometry test?
Yes, so this can get a little bit complicated, but essentially a mass spectrometry test separates and then identifies the substances in the sample based on what was gathered. So as you can see in this demo, Bertie Darrow had previously mentioned that they were repainting the house. And so what I did is I took samples from the substances on the porch of the house and then the outside and the inside of the house.
And how does this test work?
Yeah, so the way this test works is it detects the exact substances found in the samples I took. So ultimately, I found through the test that there were large quantities of paint thinner instead of, say, gasoline.
Was gasoline ever found in that house?
No. Based
Objection
on
to
my mass.
Objection to 403, more prejudicial and probative. May I be heard?
Oh, yes, please.
Your Honor, this image misleads the jury as it does not 100% represent the size, shape, and anything else of Bertie Darrow's house, and therefore it is misleading the jury into believing something that is not 100% true.
Your Honor, may I
Response?
be heard?
Mhm.
If we look back at Rule 403, evidence has to be substantially more prejudicial than it is probative. The probative value here is to show the members of the jury that Bertie Darrow had a house, painted the walls, and then this expert went and tested those walls for paint thinner. There is no misleading value. In fact, it goes back to the weight, not admissibility of the demonstrative. They could cross on it if they would like to poke holes in it.
I tend to agree, but prosecution, can you point me to the specific part in this exhibit, in this demonstrative, particularly that you find to be substantially more misleading?
Your Honor, no foundation has been laid as to what the interior of the house of Bertie Darrow's house looks like, and therefore this could be a completely different representation of what Bertie Darrow's house actually looks like. So if the interior of Bertie Darrow's house is completely different from what this looks like, then this misleads the jury into believing something that is not 100% true.
That's okay. I think that's an issue for cross. If you feel like this, I do agree with you that I don't think this is what Bertie Darrow's house inside is for, but I do believe defense is using this only as a demonstration for Miss Reynolds' investigative process. On those grounds, I'm going to overrule. I encourage you to cross on it, but I will also make it abundantly clear to members of the jury that this is just a demonstration and not the actual interior of the house. So an instruction will be given to the jury. Please proceed.
Yes, sir.
Yes, Your Honor. Ma'am, redirecting you back to my question. Was gasoline ever found in Miss Darrow's house?
No. Based on my mass spectrometry test and the samples that I found, it wasn't.
So taking a step back, what's your conclusion on this case?
Simply put, alongside the fact that Miss Darrow was financially unstable and in debt, the fire accelerant that the prosecution's investigator noted may be incorrect.
Thank you, Miss Reynolds. At this time, Your Honor, no further questions.
Thank you. All right, let's cross-examination.
Yes, sir. Now, Miss Reynolds, you were paid $15,000 to investigate this case. Is that correct?
I was. So, as part of my job, I am being paid as an insurance inspector alongside the extra task and the sampling that I took. So, yes.
A simple yes or no would suffice. And this $15,000 was added on top of your normal salary. Is that correct?
Right.
So you would say that you are an insurance inspector. That's correct?
I am.
Are you aware that Dr. Harley Blaze conducted the same investigation you did on this fire?
That's true. Not the same, but yes, they did investigate.
And she is an actual fire investigator, isn't she?
That's true.
So wouldn't she be more qualified to reach a conclusion on this crime?
So even though I am an insurance inspector, I actually have experience in fire and structural failure investigations. So in terms of qualifications, I think I do have the expertise, but I think you would be correct. So yes.
So you used to be a police officer, am I right?
I did.
But are you an officer at the moment?
No, that's not true, yes.
And in fact, you've been retired from the police force for 5 whole years, isn't that right?
Right, and then I took that senior insurance investigator position.
But Dr. Blaze is still an active investigator of the law, isn't she?
Right.
All right. Now, I want to talk about whether or not Bertie Darrow actually forged the fire. Now, on direct, you mentioned how paint thinner was found in Bertie Darrow's home.
Yes, that's true.
But Bertie Darrow had just painted his house, isn't that right?
Right.
And in your opinion, would you say Bertie Darrow has a large house?
I'm not quite sure.
And in your opinion, is it common to use paint thinner when painting a house?
I would say so, yes.
So, given the size of the house, wouldn't it make sense that there would be a lot of paint thinner on the house?
Yes, I would say so.
All right. Now, you read Dr. Harley Blaze's report on the fire, isn't that right?
I did.
So you're aware she conducted the same test you did, the GCMS test.
Right, the gas chromatography mass spectrometry test, yes.
So then you know that her test came back showing gasoline as the likely accelerant from the fire, not paint thinner.
Right.
Could this difference be because of the fact that Dr. Blaze is more experienced than you?
I wouldn't say so. So again, in terms of expertise, we both have experience in fire and structural failure investigations. I mean, we both joined the police force. I am an insurance investigator, so I'm able to look at the different aspects of the case, but I would say no.
So then, Inspector Reynolds, why is there a difference?
So that's a great question. So in terms of, I can only speak to the tests that I conducted. but I took samples on the interior and the outside of the house. And so when I took the samples and the test separated all the different elements, I found that it was paint thinner.
All right. Now, on direct, you also said that there wasn't a lot of furniture in the house. That's right?
Right.
And during your investigation, you found out about Bertie Darrow's gambling situation?
I did.
So this means you knew he was deep in debt.
Yes, that's true.
So wouldn't it make sense that someone who's deep in debt wouldn't be able to afford such expensive furniture such as laptop, TVs, and personal computers?
Honestly, it's not my place to say. I do agree that they were deep in debt, but in terms of buying furniture, I'm not quite sure.
All right. Your Honor, I have no further questions.
Thank you, counsel. Any redirect?
Yes, Your Honor. Ma'am, let's pick off where the state left off. The state just asked you about Bertie Darrow repainting the interior of her home. Ma'am, can't paint thinner be the cause of this fire, even if it was placed there to repaint the house?
Yes, and that's shown through my mass spectrometry test. And so in this test, after I took the samples, it was confirmed that it was paint thinner instead of gasoline.
Thank you, Miss Reynolds. Your Honor, no further questions.
Thank you. Any recross based on that redirect?
No recross, Your Honor.
All right, Ms. Reynolds, you're excused. Thanks to the court. With that, we are doing really good on time.
Your Honor, with that, we actually rest our case in chief.
That too. Thank you.
Yes.
We're doing good on time. Why don't we take a 5-minute? What kind of break do you guys want?
A 5-minute break sounds fine with us, Your Honor.
5 minutes sounds good to me. Let's get back to 7:50. We are back. Let's go into closing arguments, should I say. Prosecution, whenever you're ready.
Yes, Your Honor. May I proceed?
Whenever you're ready.
Revenge is the fire that consumes. Today, the prosecution has shown you how on July 1st, 2024, the defendant knowingly set a fire to Bertie Darrow's home while he was asleep. An act of revenge years in the making. And on the night of July 1st, 2024, the defendant carried out this act for revenge. Let me take you back to where it started for the defendant. Years ago, she had her whole future planned out. A scholar at Aberdeen High School on her way to do big things. But one day, she was caught by Bertie Darrow robbing a pawn shop. And like that, her future went up into flames, causing her to seek a path of revenge. Now, members of the jury, today prosecution has shown you that the defendant is guilty of first-degree arson and first-degree attempted murder. We have shown you that the defendant had the motive, the knowledge, and the planning to commit this heinous crime. Let's begin with the motive. You heard today from Ms. Huxley that the defendant was serving time in prison after Bertie Darrow caught her for robbery. The need for revenge grew as she served a 3-year prison sentence. And on the night of July 1st, 2024, the defendant allowed her need for revenge to fuel her flames, sending Bertie Darrow's home up into flames, almost taking his life with it. And members of the jury, let's discuss the knowledge. You also heard from Ms. Huxley today that the defendant had the knowledge of setting a fire. After being sent to work at the prison where Ms. Tanks was housed, Ms. Huxley overheard a conversation between the defendant and another inmate. The two discussing the perfect way to start a fire because this wasn't just any inmate. This was an expert arsonist. Now, members of the jury, let's finally discuss the planning. Today you heard from Mr. Parks that the defendant had came to stir nuts and bolts on the night of July 1st. But you had also heard that the defendant had drew a drawing from a prison therapy session, and within this drawing was marked that exact date, July 1st, 2024. Now, when she had came into the store, she came in frantically in search of gasoline. But when Mr. Parks told her that there was no more, she went in to panic, spiraling, wondering how she would be able to carry out this plan. But members of the jury, there was another option. There was a spare tank of gasoline, and when Mr. Parks went to search for that spare tank, the back shed was wide open, and the gasoline tank was missing. And then he seen a car that looked just like the defendant's, heading into the direction of Willow where Bertie Darrow lived. Members of the jury, they also try to tell you today that the defendant didn't have the opportunity. However, you also heard that the defendant had left the store, nuts and bolts, at 10:40 p.m. that night. Now, you also heard that Mr. Parks lives in Willow. And on that night, it took him an hour and 30 minutes to arrive home. But this is including a 15-minute traffic delay and 20-minute stop to watch fireworks. Now, if the defendant went directly to Willow, it would have taken her an hour and 15 minutes to get there without any stops, giving her the perfect time to make it there before midnight and the perfect time to get her revenge on Bertie Darrow. But members of the jury, the evidence doesn't stop there, though. Today, you heard from Dr. Harley Blaze that she conducted a GCMS test. And after conducting this test, she determined that the substance found at Bertie Darrow's house was indeed gasoline. And with her expertise, she determined that this was a substance used to set the fire at his home. Members of the jury, the defense is trying to spin this story onto the only victim here today, Bertie Darrow. But we ask you to not let them shy away from the true culprit of this crime, Jimmie Tanks. Because today, with my co-counsel Brenin Blanar, we have left you with evidence proving beyond and to the exclusion of every reasonable doubt that the defendant is guilty of first-degree arson and first-degree attempted murder. The defendant allowed her need for revenge to consume her like a fire. Then she set her nemesis' house ablaze. We now ask that you put that fire out and find the defendant guilty because the defendant forged her revenge. Thank you.
Thank you, counsel. Defense, closings whenever you're ready.
Yes, Your Honor. Can you hear me and see me okay?
Yep.
I'm just gonna pull up a stopwatch. She needed funds, so she started a fire. The prosecution keeps telling you that revenge is the fire that consumes. But the thing is, Bertie Darrow's need for funds is what really consumed her. They have it right. Revenge is the fire that consumes. You see it all the time in movies. That's what the prosecution wants you to believe. Members of the jury, speaking of movies, consider this. Imagine going to see a highly anticipated movie where the public is consumed by rumors of a brilliant lead actor. But when the lights dim and the curtains draw, you're just left with a cast of supporting characters that merely talk about the lead without ever showing them on the screen. You see, the prosecution is consumed by the heaviest burden in America's legal system. They don't just have to prove their case with evidence, witnesses, and witty words. They've got to prove beyond a reasonable doubt that Miss Tanks is guilty. And if there's even a single possibility that consumes your mind that Bertie Darrow, not Jimmie Tanks, burned down that house, then Mrs. Tanks isn't guilty. You see, Jimmie Tanks didn't take the stand today. But that doesn't change the fact that she's innocent until proven guilty. It's her constitutional right not to testify. The same right that every person in this room, you and me, have today. But it doesn't matter, because today we've proven that Bertie Darrow burned down that house with the funds and the fire. First, she needed funds. Bertie Darrow's finances are fueling her financial instability. She's consumed by debt. The hardware store worker even told you that Bertie Darrow couldn't even afford to pay for the paint thinner she bought from him. But she won't have to struggle anymore if she comes out of today's trial with that grand sum of almost $1 million. You saw her debt summary today, members of the jury. She was $225,000 in debt. The second, she forged a fire. Now, how do we know that? You heard from the insurance investigator who even showed you that a house is similar to how Bertie Darrow's house was covered in paint thinner, not only on the walls, but also on the porch. And the store worker even told you that Miss Darrow purchased way more paint thinner than she would have needed to paint her house. She didn't want to paint a property. She wanted to soak it and then let it go up in flames. Let's talk about how the state expert was consumed by the need to blame this crime on someone. Today, you heard the state's expert agree on cross-examination to only suspecting Ms. Tanks. Folks, think back to the analogy that my co-counsel gave you. If I were to turn my back on all of you, I wouldn't be able to see what you're doing. That's what happened today. The state's expert only focused on Ms. Tanks and failed to see if Miss Darrow would have or could have forged a fire for funds. Now, I want to talk about something that's been consuming me for this whole trial. Now that I think about it, the state has talked a lot about Bertie Darrow. Miss Curry even said we've tried to shift the blame on the only victim here. But Miss Darrow isn't even here. Look around this Zoom call. I see Judge Jang. I see Miss Garcia. I don't see Miss Darrow because the state chose not to call her. Instead, they chose to use her trauma to win pity points. And the state couldn't bring her because if they did, you'd see the truth that she was consumed by that need for funds. It's just so easy to paint a narrative when the canvas isn't here. But in order for the prosecution to fulfill their burden, they not only need to prove that Jimmie Tanks started this fire, they need to prove that Bertie Darrow sustained serious bodily injuries. But members of the jury, you didn't see a single piece of evidence proving Miss Darrow sustained any serious bodily injuries. So members of the jury, when you go into that deliberation room today, on this count, you're going to check no. The law requires you to, because you didn't hear anything concrete about any serious bodily injury. No medical records, no photos, no videos. That's right, members of the jury. No evidence. You only heard a witness mention, seeing it from afar. The prosecution keeps telling you today that revenge is the fire that consumes. But I want you to think about who had something to gain from that fire. What would Jimmie Tanks get from a revenge that supposedly consumed him? Petty catharsis? Revenge? He'd spend time in jail for the second time in his life and have another felony tacked on his record. And Miss Darrow, on the other hand, she'd get more than $900,000 in compensation, more than enough to pay off her debt, the debt that was consuming her, members of the jury. Bertie Darrow needed those funds. So she started a fire. Find Jimmie Tanks not guilty. Thank you.
Thank you, counsel.
Yeah.
Rebuttal?
Your Honor, before prosecution begins the rebuttal, I would like to note that the demonstrative used in the defense's closing was not shown during captain's meeting. I don't know what you would like to do about that, but it has not been shown to us.
That's not a question for me. I think if we have an issue with that, we can deal with that. Maybe Ian, should we deal with that after trial or?
Okay.
Yes, we'll proceed with rebuttal, and then if a protest is filed, we'll point to a rule and go from there.
That's what I'm thinking as well. Perfect. All right, Ms. Curry, I believe you have 30 seconds for rebuttal. Please proceed.
Yes, Your Honor. In an attempt to turn this arson and attempted murder into an insurance fraud, the defense has failed. In the cross-examination of Inspector notes, you heard how she found large quantities of paint thinner. But she even admitted that because she found these large quantities of paint thinner because Bertie Darrow had just repainted his house. Members of the jury, I have a question for you. Bertie Darrow is the first one to be in debt. Bertie Darrow is the first one to have a gambling addiction. This has to mean that he set his own house on fire for a payout that he wouldn't even receive. So while Mr. Darrow may not be here today, the blame is being put onto him. So we urge you to find the defendant guilty, because the only thing that was forged in this case was the defendant's need for revenge. So when you see that jury verdict form, you will select not guilty.
Thank you. I was gonna call time because it was a little bit too over, but the trial is finished, and give us a few minutes and so we can all finish our ballots, and then Ian, I believe, it's comment time. Right.
That's right.
Awesome. So first off, congratulations on a great performance, everybody. That was a lot of fun to watch. You guys should be very proud of making it here. Only 4 teams made it to the semifinals. You guys were one of the top 4 teams in the competition, and that shows. I think first thing that I really want to highlight is before round, I told you guys to do something fun and unique and new to the round. And I felt that in a round. I felt both sides were being very responsive to what the other side was doing. I heard a lot of theme flips and headers. That was great. I heard a lot of responsiveness in the closing arguments. That was fantastic. A lot of strong moments that I really think made the individual competitors shine. I think going forward, if either of these teams are for the team that is advancing, if you go the same side, depending on which team it is, I think that's something that's very important is just remembering, especially for a judge like me, and might be a judge that you have in the finals round who hasn't read the case packet. There were a lot of gaps I was missing in the story. And I felt like we were making a lot of logical jumps on witnesses. And I think that especially becomes a problem in a round like this, given the witness calls. Because I'm not hearing testimony from the victim or the defendant, because those are the witnesses that you chose not to call. And I'm not saying you should call them. I think the witnesses you have are fine for the theory. But it means that on your other witnesses, you need to put in a little bit more legwork on the storytelling. And I think that's going to be very important because, again, you have moments like going to shout out Audrey on the close where she points out because you don't have the victim testifying, you need to find another way to get that physical injury prong in of the charge. Like that's a really strong moment in Audrey's closing where she gets to point out the fact that we didn't hear testimony of that. And so you can check no there. So just really going forward for either team, if you can find ways to fill the gaps in the story and keep doing what you guys are doing in terms of reactiveness to what's happening in trial, flipping their themes, flipping their demos, responding specifically to the answers the witnesses give, I think you guys are going to continue to do great things.
Yeah, hi everyone. My name is Alex, and I'll echo everything that Judge Ashlock had just said. I thought both attorneys and witnesses were very strong in this round, and I think you should all be very proud of yourselves. Again, the top 4, that's an incredible achievement, and regardless, I think you all performed very well. Something I will say, I think pausing and pacing could be utilized a bit better regarding statements, just taking a moment and then letting that moment sink in and then starting your statement before just jumping right into it. And sometimes with directs, I noticed they were on the faster side a bit. Remember, you want it to be more like a conversational pace and as if the witness is hearing it for the first time. And of course, that's really hard making something scripted sound organic for the first time. But again, I thought it was a very great round. I think those minor performance things will really push you guys to that next level. And I think it's something to consider, but regardless, you all did a very great job.
I absolutely resonate everything Drew and Alexandra said. Phenomenal job, everyone. Now, I'm not a lawyer, so I cannot say the spiel about you are better than all the lawyers I work with. I can't say, as a college student, that you were way better than I was in high school. I will say, I think this was a great round to watch. I think it was very fun. It kept me focused. But I also do agree that with Bertie Darrow and Jimmie Tanks not being called, there are some things that I think prosecution could have pointed out as well. Because when I heard that defense close, when you were pointing out that Darrow wasn't there, the first thing I thought you should do on rebuttal was the fact that Tanks isn't there as well. So if you point that out as well, it kind of counters that point a little bit more. I think overall, everyone could be a little bit 20% slower and a little bit more casual as well. I think for especially for defense, obviously you guys are very well polished. You guys are very well stylistic, dramatic, very well in that regard. But I think for some of the statements, for some of the crosses, there can be more casual pockets to kind of indicate more of a juxtaposition in order to kind of have a varying. I mean, I think that's the one thing that stood out to me. I think everyone was very confident, and I think overall, I really agree with what Alexandra said about the directs. It could be slower. Consider employing what we usually call tennis balling, where you kind of throwing imagine if you were in a real courtroom, you're after the directing attorney asks a question, they throw a tennis ball to the witness. After the witness catches it, they begin to respond. It's paying attention to things that make your direct flow more naturally. That brings this to the next level because it's already very responsive and rhetorically, it's already doing very well. No matter the outcome of this trial, I think this was a very, very close trial, as indicated on my ballot for sure. And great job to both sides.
All right, folks, it's time for the announcements. Let's start with the MVPs. Your most valuable witness in this round, by unanimous decision from the defense, Ethan Bai. Your most valuable attorney in this round, on a split decision from the defense, Christiana Garcia. This was a tough round, well fought, and your judges has given you paragraphs and paragraphs of feedback. But advancing to the final, top 2 out of 44 teams, the defense. Congratulations to both teams. Your ballots and feedback are in the chat right now.